All right, everyone, we are live. Make sure you turn your cameras on, please. Very important, have your cameras on. Otherwise, it doesn't count towards your hours. I got somebody asking here for support real quick. All right. Good. All right, in the first couple days, there's always these technical issues with the new students. But eventually, by the 4th week, we should be okay. All right, let's see. What do we have here? Make sure your names are correct. Sam, please change from, hi, how are you? Please change from your email to your actual name, please. Zoom user, whoever you are, Zoom user, change your name. Cameras on. Let's see. I have Marta, good morning. I have Ophelia, Alexis, Danny, Leonard, Sam, Snady, right? Did I say it right? Snady? Okay, cool. It was tough yesterday, so I just want to make sure I got your name right. Just messing with you. We have Marlene. I still have a Zoom user, but no name. And Vanessa's watching too. All right, cool. All right, I don't see any questions pop through. Do you have any questions regarding yesterday's chapter or any questions regarding the classes before I go into the actual chapters? Let me know now so I can address them. Whoever's watching on YouTube, you can also ask questions as we go in the Zoom chat, okay? Hold on, this is weird. Somebody cannot sign. A1, I see you there. Promise I'll start right now. Okay. All right, guys. So apparently there was an issue with the meeting ID. The person, my assistant, when she posted, she made a mistake with a couple of numbers, but the link is correct. So if you ever try to join the class, always try to go by the link directly, because that's the same thing that I use. If you need the meeting ID, it should match, but the meeting ID is also embedded in the link. So I do apologize for anyone that had difficulties logging in this morning. Okay, I'm already correcting the issue. All right, cool. So we're live on YouTube. We're live on Zoom. All right, some people just join us. Cool. Nav, good morning. Tiana, good morning. All right, cool. Sam, your name still shows as an email. Can you change it, or you can ask Nav to help you? Just messing with you. All right, guys. Make sure cameras are on. Very, very important. Otherwise, it doesn't count towards your hours. I'm telling you, I'm gonna record this so I can hit the replay button as many times as I can. Nidia was able to log in. We're good. All right. Why are you raising your hand already? No, we're Juan. The meeting ID. It changes with every chapter. So every chapter is a new meeting ID. It's posted every day. But if you click the link, it brings you directly to the Zoom session. Right. All right, cool. So sorry I had to rename a few of you because I need to have the correct names. Otherwise, it doesn't count towards your hours when we do the attendance. If names mismatch, then I don't know what hours you did, okay? All right, Nav, I don't know what happened to Sam, but she dropped. Make sure you bring her back. Make sure your camera's on. Hey guys, so important. I don't know how many times I have to repeat this. So important that your cameras must be on facing you, okay? All right. Having a hearing. I'm sorry. Yeah, I did not understand what you wrote. Can you please explain? You're having a hearing the meeting? Hearing the meeting? What's a hearing the meeting? All right. All right, guys. So we're going to talk about ownership. This is a chapter. Sucks that it's the second day and you get this chapter right away. This is one of those chapters that things get a little complicated. We're going to slow down in a couple of things, mainly here in the co-ownership. And then we'll slow down again when we get to condos and co-ops. All right? So slow down, speed up, and then slow down again. Now, we're going to talk about sole ownership. Remember, guys, this is title. So in terms of ownership, it's title. How do we own the property, right? Is it as an individual? Is it as a group? Is it as a business? So how do we own the property? If it's sole ownership, means that there's one person or one entity. So an LLC owns the property, not the members of the LLC. If it's one owner only, right, or one entity only, it's called tenancy in severalty. All right, sorry, Tiana, you're having problems hearing? Having issues hearing the... You can't hear? Okay. Tiana, log, and log. All right. So, guys, if you ever have problems with the meeting, the easiest way to solve them most of the times is just get off of Zoom and come back in. Right? So literally get off of Zoom, come back in. That's it. So if you cannot hear me for any reason, always get off of Zoom, come back in. All right, so again, sole ownership means one, and we call it tenancy in severalty. What confuses most people about this is because it says severalty, right? Several means a lot, right? So when you see severalty, several, and then where they put T at the end, severalty, it's cut off from everybody else. Severalty is cut off from everybody else. So you are just one, separate from all people. Separate from all people. Oh boy. Severed from all people. So one. So if a single party owns the fee or life estate, if a single party, one party owns the fee or life estate, and I'm so sorry, guys. I need to have a technical support just for the classes. All right. So this time we're not stopping. We're going to move forward. So again, if it's a single party that owns the property, then it's a tenancy in severalty. And I think you guys remember the word tenancy. We talked about freehold and leasehold tenants, right? And the issue is that most people see tenancy and think about renters, right? But no, tenancy means occupant. So if we have tenancy in severalty, is who occupies or has possession of the property. Is it an individual or is several people, right? If it's an individual, tenancy in severalty, sole ownership or ownership in severalty means the same. When the would-be owner is a husband and wife, state laws may require homestead, dower or elective share, rights to be released to allow ownership to be free and clear of any marriage-related claims. The estate of a deceased tenant in severalty passes to heirs by probate. Okay, so that severalty is just one. Okay. Now, co-ownership means there's more than one person. Co-ownership means there's more than one person. Right? So there's different forms of co-ownership. There's joint tenancy in common or TICs. There's joint tenancy. There's tenancy by the entireties. There's community property and tenancy in partnership. When we're talking about tenancy in common, also known as TICs, it's 2 or more people. So let me make it 2 plus people not married. Okay. JT, or joint tenancy, is also 2 or plus people not married. I'll explain the difference between these in a little bit. Tenancy by the entirety is husband and wife, or spouse and spouse. All right, and these we'll address later. So tenancy in common, JT, are the ones that are going to confuse you the most. I want to make sure I take my time explaining these two. But these are TICs, JTs. It's for 2 or more people not married to each other. Okay, so we're on page 40, and we're going to start with tenancy in common, or TIC. Tenancy in common or TIC. So tenancy in common is also known as estate in common. And this is the most common form of ownership when the owners are not married. Again, it's the most common one when owners are not married. So the defining characteristics is that there's 2 or more owners. We have identical rights, so we have common or equal rights. The interests are individually owned. We have electable ownership shares, so we can choose to own 15%, 20%, 50-50, whatever. There's no survivorship, and I'll explain that better later. And there's no unity of time. I'll also explain that better when we get to JTs. So 2 or more owners means that any number of people may be co-tenants in a single property. It could be 100 people to own the property. The fact that it's more than one changes from severalty, cut from everybody else, to joint, where or co-ownership or co-tenant, because there's more than one person. Okay. Identical rights. That means we have an indivisible interest. Right? If you guys remember undivided indivisible interest, we talked about yesterday briefly. In undivisible or indivisible interest, we said that I cannot own the first floor or the second floor, right? I cannot own the left side of a duplex or the right side of a duplex. We own the property together, and maybe we occupy one unit and you occupy the other, right? But we own the property together. There's no physical separation, right, of what's mine and what's yours. Because on the deed, it shows both of our names. Therefore, both of us wholly own the property. There's no separation of the ownership or the rights. Okay? All right. Interests individually owned. All tenants in common have distinct and separable ownership of their respective interests. Co-tenants may sell, encumber, transfer their interests without obstruction or consent from the other owners. So because we own our shares independently, right? We own the building together, but we own our shares independently. We can always sell our shares whenever we want. Now, if we cannot sell our shares, then we can force the sale of the shares or the building. I'll explain that better in a second. But I can try to sell mine, or I can try to mortgage mine, right? But I cannot encumber or pretty much sacrifice or cloud the entire property, okay? Just because I'm part owner doesn't allow me to take over the whole thing, right? So it's either we both do it or nobody does it, okay? Electable shares, like I said, it varies. So it's not necessarily 50-50. But this is important. In the absence of stated ownership shares, so if I did not say, Tiana, you can hear me now? Okay, great. So I'm going to use it, Tiana. So for the example. So let's say that we own property together, Tiana. You and I own property together. I put $1, you put $99. How would our shares, and before you guys think you can buy a property for $100, yes, it is possible, not very common. But I put $1, you put $99. How are our shares divided? Let me know, Tiana, or anybody else. How are our shares divided? All right. And Sam gives us the right answer. If we don't state specifically, then equally. If we don't state specifically, then it's equally shared. All right. So again, in absence of stated share, so just because you put $1, I put $1 and you put $99, doesn't mean our shares are divided 1% and 99%. Right? If we did not state in the paperwork, in the deed at least, that I own 1% and you own 99%, then automatically it is assumed that each share is equal to that of the others. All right? So you guys need to understand that the deed, when there's no partnership agreement, the deed becomes the partnership agreement. The deed is the ownership agreement. You understand? So that's where we stipulate what belongs to one party, what belongs to another party. All right? Very, very important you guys remember this. The deed describes the ownership. So if we don't make a statement about how we own the shares, then automatically is equal. Right? Now, Tiana, do you think it's fair that I put $1, you put 99, and we have 50-50? It is fair? I put $1, you put 99, and our shares are 50-50? Is it fair? Is it not fair? You said yes, then you say no. Decide yourself. Choose one. When you go to the school exam or state exam, be decisive. Choose one. All right. So guys, it depends. What I want to point out at this moment is that a lot of investments are created this way. Look, I'm going to put $1 because I need to put something of nominal consideration. I'm going to put $1. But Tiana, you're putting more money, but you're not going to manage the property. I'm the one that's managing the whole investment. So my expertise, right, my labor, right, it's called sweat equity, is worth as much as your $99. So I put $1 just to say I have the foot in the door, right? But then everything else is going to be my work. And a lot of investors work this way. They raise funds where other people put more money. They raise funds, but then the one person is going to manage or maintain the property or fix or rehab or whatever. So again, how much money you put in does not determine the shares that you have. You have to be very specific to the shares that we have. Is that clear? And that goes for even a partnership, right? This here is what's going to be on the deed, but that goes even for partnerships, right? All right, next, there's no right of survivorship. There's no right of survivorship. What does that mean? So you guys are going to learn from, we talked about homestead, we talked about dower and courtesy and elective shares, right? So you're going to learn that when somebody dies in certain types of ownerships, the other party acquires their interest right away. So let's say, Tiana, I'm sorry, I'm going to kill you for a second. Is that okay? Right, cool. So if you die and we have, for instance, a joint tenancy, as we'll talk about later, or if we're married, or as we talked about yesterday, what will happen is I acquire automatically your shares. I become the owner. That's called a right of survivorship. In a TIC or tenancy in common, we don't have a right of survivorship. In a TIC or tenancy in common, what you own is yours. What I own is mine. So that means that when I die, or if I die, my shares go to my heirs. If you die, your shares go to your heirs. All right? So there's no right of survivorship. Each person owns their own shares individually and can pass it along to their heirs. Also, there's no unity of time. And we need to know this again for the JT, which is the next one. These two are pretty much based on the JT or joint tenancy. No unity of time. What does that mean? It means that when we purchase a property as ticks, when we purchase a property, right, I can buy it today and add you tomorrow. It'll automatically be a tick. For a JT, as we'll talk about later, for a JT, we have to buy it at the same time. We must be united by the same deed at the same time. Our name needs to show up on the same day in the document. All right, so it cannot be altered later. It has to be on the same day. So here it says it's not necessary for tenants in common to acquire their interests at the same time. All right, so what we have here is a little more complicated than what I usually do. So I'll show you my drawings are a little bit better, since I'm an artist. They're a little bit better, all right, than these ones. But this is just a quick illustration. Initial interest, we have A, B, and C. C sells his shares to D and E, so that we all have different shares, right? Upon the death of the owner, right, let's say A dies, can will to D and E, so the kids, for instance, right? So this all creates new shares, all right? But before we get to this, I prefer to show you my way, and hopefully that will help you. All right, so we're going to assume that this circle right here means 100% ownership. Okay? So 100% ownership, right? Now, if there's only one person here, A, what type of ownership is this? This thing means 100% of the shares, right? If there's only one person, what type of ownership is this? Who can tell me? I know it was a long time ago, right? It was roughly like 15 minutes ago. So yeah, it's a long time ago. And the answer is sole ownership, correct. Tenancy and severalty, and tenancy and severalty. Yes, Ophelia, ticks are for two or more people not married to each other. So if it's one person, it's a sole ownership. In this case, we call it tenancy or occupancy or possession in severalty. So severed from everybody else. So this right here illustrates tenancy in severalty. Okay. Now, what happens when A dies? Well, when A dies, the shares go to heirs. They take over, right? So I'm just going back to what we read, illustrating for you guys right now. Then we'll talk about ticks, and this is before we get into JT, which will be the most complicated one, okay? So in the simplest form, if it's one owner, tenancy and severalty, right? One owner has 100% ownership. If owner dies, the shares go to heirs. Simple as that. Now, what if we have A, B, and C, and the shares are unequal? What do we have here? So this still, the circle still represents 100%, and then we have different shares for everybody. And of course, I have to get the biggest shares. I'm just letting you know. The majority of shares are mine, always, all right? So what type of tenancy or what type of ownership is this? Let me know in the chat. All right. We have 2 participants. I expect more. Thank you very much. Okay, very good. Danny, we didn't get to join Tenancy yet. Marlene, we didn't get to join Tenancy yet. Tick, tenants in common. All right. By the way, there's no wrong answers as long as you answer. Okay, because then I'll explain. So this is an example of tenants in common. Ticks. All right. Now, what are the distinguishing characteristics? Why is this not a joint tenant? One, we didn't get there yet, so it's impossible for you guys to know, okay? Number 2, the first thing that identifies this as a tick instead of a JT, the first thing, the biggest difference between them, right, is the fact that we have unequal shares. When we get to JTs, you guys are going to realize that the shares have to be equal. So if there's 3 people, it's 33.333% owned. If there's 2 people, it's 50-50. If there's 4 people, it's 25% each. So equal shares in a JT. But in a tick, it could be equal shares, but it's also okay to be unequal. So I can own in a tick, I could own 50%. You could have 20%, and then here 30%. These are unequal shares, and it's okay. Everybody owns their individual units or shares. Okay, very important to know this distinction between a tick and a JT. All right, in the state exam, or even in the school exam, if the question shows equal shares, don't assume automatically that it's a JT. We got to read a little bit more. But if it says unequal shares, or if it says A owns 30%, C owns 20%, and B owns 50%, if it shows unequal shares, automatically, that's it. It's a tick. Okay? There's no other way around it. There's no other option. There's 2 or more people and unequal shares, automatically is a tick. Tenancy in common. Okay? Thumbs up? Good. All right, so what happens when C dies? What do you guys think? When C dies, what happens to C's shares? Work with me. What happens to C's shares if C dies? You're confused. Marlene, you're trying to be ahead of the game. That's a JT. We're talking about ticks. It goes to heirs. Okay? They are individually owned. These shares are individually owned. In a tick, the shares are individually owned. Therefore, when C dies, the shares go to heirs. So it's A owning 30%, it's B owning 50%, did not change their shares, but C shares are now owned by the heirs. So now A and B have to deal with C's heirs, kids, spouse, whatever. All right? Very important. This only happens with 2 types of ownerships. Remember this. Tenancy in severalty, so if it's one owner, goes to heirs. Tenancy in common, 2 more owners, not married to each other. Okay? Goes to heirs. When we get to JT and we get to tenants by the entirety, which is husband and wife, then there's a survivorship or life estate. All right? So make sure you guys get the separation of it, because, again, a lot of mistakes are made here. If it's a tick, shares go to heirs. Okay. Now let's talk about the next one, JT. Okay. Joint tenancy. In a joint tenancy, two or more persons collectively, not individually, collectively own a property as if they were a single person. There's two or more people, but we own it collectively as if we were one, just like in the marriage. There's not husband and wife, it's one ownership, which is the marriage itself. So the rights and interests are indivisible and equal. This is key. In the JT, they're indivisible and equal. Okay? And each has a shared interest in the whole property that cannot be divided. Now, joint tenants may only convey their interest to outside parties as tenants in common interests. So if I sell my shares, the person that comes after becomes a tick with our joint tenancy. I'll explain this better. Okay? I can never convey the joint tenant interest. Now, what is the joint tenant interest? The joint tenant interest is the unity of ownership. That means we own it together, right, as one. Equal ownership, transfer of interest, or survivorship, right? I cannot transfer this. If I sell the property, or if I sell my shares, then I destroy all of these for that particular entity that's buying into the property. Again, I'll explain better in a second. Okay? So unity of ownership, whereas tenants in common hold separate title for the individual interests, joint tenants together hold a single title to the property. Equal ownership, joint tenants own equal shares without exception. So if there's 4 co-tenants, each owns 25% of the property. If there's 10 co-tenants, each owns 10%. Doesn't matter how much money they put in, right? So let's go back to my example with Tiana. I put $1, she puts 99. Does not matter. In a JT, we are equal, period. Does not matter how much money you put in, you're equal, period. In a tick, we could define that I have 1% and she has 99%, right? But in a JT, does not matter how much money put in, our shares are equal, period. Okay? David, thank you for joining us. How's everything? Good, all right. Transfer of interest. A joint tenant may transfer his or her interest in the property to an outside party, but only as a tenant in common interest. Whoever acquires the interest co-owns the property as a tenant in common with the other joint tenants. I'll explain in a second, I'm sorry. And the remaining joint tenants continue to own the undivided interest in the property, less the co-tenants share. Survivorship. Now this is key. Survivorship. In most states, joint tenants enjoy the rights of survivorship. So if one joint tenant dies, all the interests and rights pass to the surviving joint tenants, free from any claims from creditors or heirs. Okay? In other states, joint tenancy does not inherently include survivorship. Survivorship must be expressly stated to be effected on transfer. When only one joint tenant survives, the survivor's interest becomes an estate in severalty and the joint tenancy is terminated. The estate will then be probated upon the severalty owner's death. I'll explain all this in a second when I go to my amazing drawings, okay? So the survivorship feature of joint tenancy presents an advantage to tenancy in common, in that interest passes without probate proceedings. So we don't have to go to probate to figure out who owns what or who gets paid what. This is automatically. On the other hand, joint tenants relinquish the ability to will their interests to parties outside of the tenancy. So, can I put this in the will if I own as a joint tenant? Can I put my share in the will? You can, but it's moot. It's not valid. It's not going to go anywhere. You can put as many properties as you want in your will, but if one of them is under a joint tenancy, unless you are the sole survivor of that group, you will never pass down to your heirs. Let me explain that better here. All right. So if you guys see right here, A, B, and C, you guys notice that there's no division of the shares? Because we own the property as one. So all shares are equal. This is the main feature. One of the main features is that shares are equal. Okay. The other main feature is if C dies, right? The only C we have here is Clenard. Clenard, I'm sorry I keep on killing you, but I'm giving it to your heirs, except on this one. If you die on this one, sorry, but you're just one less person in the group. A and B are now 50-50 owners. Your heirs don't get anything, all right? All right, but let's assume, and this is only by logic, okay? Let's assume the next one to die is Alexis, because I gotta survive. You know how it is, right? So, Alexis, sorry, you're dead. You think it goes to your heirs? No, it does not. Of course, in the end, there can only be one, and that one is me. So, even the saying says, in the end, there can only be one. So, B, one. Simple, right? I'm always a survivor. I'm always the winner. Sorry, guys, your heirs get nothing. Absolutely nothing. All right? But at this moment, if there's only one survivor, what do we have? What type of tenancy is this? Let me know in the chat. For those of you that are old enough, I hope you got the reference of in the end there can only be one. The Highlander, right? The Immortals, no. Christopher Lambert, the actor. All right. It was pre-Facebook, so maybe you guys don't remember anymore. But yes, sole ownership in severalty. That means if I die, if I happen to die, which is most likely not going to happen, but if I happen to die, my shares go to whom? Who gets my shares at this point? Because I'm the survivor of the group, I'm the sole survivor, I'm the only one whose will be made. So, goes to my heirs. Everybody can put in their will, but they have to survive in order for this to have effect. Okay? So only the last one can transfer to the heirs. Very important. Oh, I have the power to resurrect people too. So Alexis, you're back. And look at that. Clenard, you're back. Boom. Like that. Right? So this only happens in my classes. There's no other class that has this power. I let you know right now. It's something that was given to me. I can do this. Boom. Everybody dead, everybody alive. Simple. Anyway, what was I going to say? So you guys figured out joint tenancy is horrible, right? You guys already figured out joint tenancy is horrible because the heirs get nothing. So why would somebody do this, right? Anybody has that question? Raise your hand if you have that question in mind. Like, why would somebody do this? All right, Juan got it. Great. So here's the thing. A tenancy in common, I see it more as an emotional decision. Like, I want to buy, you're my partner, Juan, and listen, this is what we're going to do. We're going to split 50-50, that's what we're doing, or 2/3, 1/3, whatever we decide. And if you die, it goes to your heirs. If I die, it goes to my heirs. But it's an emotional decision. A joint tenancy is a more cold business decision. Why? The way I see it is very simple. if you die, then I'm going to be co-owner with your heirs, right? Now, I know you guys have some type of investor or entrepreneurial spirit, otherwise you wouldn't be here. So you kind of want to be in business, so you kind of understand what business is, and you want this, right? You like real estate. What about your heirs? I don't want your heirs, like your spouse or your kids, to show up and say, oh, Bruno, yeah, so Juan is dead. We want to sell this building because we want our money. And they can force me to do so. It's called partition. They can force me to go to court and sell the building in order for them to collect their part of the building, right? Do you think that's fair to me, Juan? Do you think that's fair that you decided to die first and then I have to deal with your heirs? Right? That's a really bad decision, man. Right? Really bad decision. So that's why we make these type of arrangements that says, if you die, right, I'll keep on managing the business. Now, this is in terms, so you guys understand why I say it's a cold decision, right? This right here is title. Who owns what? There's nothing wrong with me and you making a decision of putting a separate agreement, maybe an insurance or an annuity or something, that when you die, your heirs will keep on receiving money from this property. It's just that in terms of title, I'm the owner, and I'll manage it as we both intended originally. Does that make sense? I will have nobody forcing me out of my property or our property. You guys understand this? Right? This happened a few years ago. A student of mine was telling me that her sister passed away, and her nephew, not understanding that the property was under a joint tenancy, right? Her nephew, not understanding, was trying to force the aunt to sell the property, right, in order to collect the money. So his mother died, and he wanted the money. The aunt said, no, I don't care about the money for me, but your mother worked hard to buy this property with me so that you would be receiving money over the years. So it's an asset for you, right? He took the aunt to court, believe it or not. Took the aunt to court trying to get the property and sell the property. Right? Of course, the aunt won because she was the sole survivor. And yes, the kids supposedly, I mean, I have to believe people's stories, but the kids supposedly still receiving money from that property versus selling it and wasting all the money, which happens a lot, right? So again, it's a cold business decision, but everybody benefits in the end. Does that make sense? Give me a thumbs up if you got it. All right? If you have questions, drop them in the chat, okay? Now, how do we create a joint tenancy? Okay? For a joint tenancy to exist, there has to be 4 unities. I'm going to show you in the book in a second. There has to be 4 unities. There has to be the unity of time, title, interest, and possession. Okay? These are 4 unities. For this to exist right here, A, B, and C must have purchased the property or acquired the property at the same time, through the same title or deed, sharing equal undivided interest and possession. All right? So we have to be equal in all aspects in order for a joint tenancy to exist. So somebody that comes after, let's say C wants to sell his shares, right? So C decided to sell his shares. Somebody that comes after now enjoys 33.333% ownership as a tick. Okay, let me zoom in real quick. So nothing stops you from selling your shares. It's just that whoever comes after didn't come at the same time or belong to the same title, right? They might have the same interest, the same possession, but they don't have the same interest. Because one of the key interests here is the right of survivorship. Okay, so C sold to D, and D lost the right of survivorship. They might have the rest, so equal shares, but they don't have the right of survivorship. What does that mean? It means that if A dies, C does not get A's shares. B does because they're the originals, right? A and B were still a JT because they're still part of these four unities, okay? So A and B were still a JT because they're still the originals, part of these four unities. So if A dies, okay, it's just one less person in the original group, all right? So today it says I lost her. Okay, let me go back. Remember that we had A, B, and C were joint tenants, correct? A, B, and C were joint tenants. So that means that they owned the property equally, right? They came in at the same time. They held, their names are on the same deed or title. They hold the same interests or rights or benefits and equal possession of the property, right? The problem was C, so Clenard here, decided to sell to David. He said, you know what? I'm done with this thing. I realized that if I die, my heirs don't get anything, so might as well sell now and get some money. That's what Clenard said, right? So, plus he was tired of me killing him in the examples. So he sold it before he got killed. Just saying. So David now has the property. Now, I have no interest in killing David because I don't acquire his shares now. David is a tick. Bloodsucker, and I can't get rid of him. All right? So he's separate from our original agreement. Our original A, B, and C agreement. He's separate because C decided, or Clenard decided to sell. So when you sell, you're breaking the four unities. You're no longer a JT. You become a tenant in common with our JT, with A and B. All right? So Alexis and me, we are still the originals. We still have the same rights, including the right of survivorship. We have the same rights, but D does not. So if D dies, because D is a tick, a tenant in common with us, if D dies, his shares go to his heirs. But if A dies, it's one less person of the original group. So I absorb A's shares, and it becomes 2/3 for me. And David had 1/3. Got it? A little bit better now? Okay. Sam, so if B, does it go to the heirs? If B dies, does it go to the heirs? Yep. So yeah, that's what will happen now. If by any chance B dies, then the heirs take over, right? And yes, JT no longer exists. The moment that A died, JT no longer exists. It becomes a tick, where I own 2/3 and D owns 1/3. So it's a tick. We're tenants in common, the two of us. So if D dies, his shares go to his heirs. If I die, my shares go to heirs. Okay? All right, David, I think I just went around. All right, guys? I'll repeat this a million times before we move forward. Let me know if you have questions. Please don't be afraid of asking questions. I see 4 people on YouTube. If you're watching, ask questions on the YouTube chat, live chat, not on the comment section because I don't see it right now. And you guys here on Zoom, again, don't be afraid to ask questions. I don't care how ridiculous you might think the question is. I prefer to explain this a million times than to keep pushing forward, okay? I'm not regulated by the Board of Education that says, yeah, just keep moving the kids. Right? I don't need you to graduate high school. I need you to understand before you graduate. Ask questions. Connie, how are you? Morning. Got Connie on you. All right, David has a question. Let's see. All right, so if you are gone, if I'm gone, you don't get a license. Just saying. So if you are gone, what will happen? Might be off topic, but I finished class from this morning and the one from later. Okay, so I addressed that, and then you're asking something else totally different. Okay, got it. Okay, so we'll talk about hours a different time because I don't know your hours right now. I need to check. Okay. Marta, I just joined today. Where can I get the booklet you're teaching from? Okay. So what I'll do right now, Marta, I'm going to. Did you get access to the student portal? Yes. Okay, great. So let me show you here real quick. So if you are in the student portal, in your computer, it'll show on the side. If you're on your phone, it'll be all the way at the bottom. But you have access to the Facebook group. You have access to the WhatsApp group, which is the preferred, where more action happens, more people share or post questions. And you have access to the book right here. Right? If you want to buy the physical book, then I can send you a link for you to purchase the physical book. Unless you already purchased. I don't know what you. Right now, I don't see your subscription. I can see it later. But if you already purchased the book, then most likely it will be shipped to you tomorrow. If you haven't yet, because you purchased today, right? If you haven't yet, then and you want the book, then I'll give you a link. Just let me know. All right, but all the resources are going to be right here in the student portal. All right, any other questions? Let me know if you have questions. Connie says, please send me the link to purchase the book. All right, Connie. Connie, do me a favor, send me a message on WhatsApp so I don't forget to send it to you, okay? So when I'm done with the class, I'll just reply to it right. All right, guys, I see some of you stretching. I'm like, stretch too. Exercise. We're ready for the next 3 hours, right? Sit. Questions? All I want, people to ask me questions. Fun. All right. So, since you guys got this, there's no questions. Let me clear all this. Really? You asked me a question after I cleared everything? Did you really just do that? So bad. So you guys know she did the same thing yesterday in the evening. Attends the morning class, goes attend the evening class, and interrupts my whole evening class. Right? Anyway, so the question was, so you guys know, the question was, what if B dies before D? All right, so because, simple, because at this point we are tenants in common, we're ticks, it really does not matter. Our shares go to the heirs, right? If D was part of the originals and I would die first, so if they were D was part of the joint tenancy, then D would acquire everybody's shares as we go, right? But because we are ticks, there's a separation of interests, right? So there's your shares and there's my shares. If I die first, it goes to my heirs. If you die first, it goes to your heirs. If we are a JT, so joint tenants, if I die first, then you acquire my shares. Just the way it is. Okay? I would assume, like, for a question like this to come, I would assume like she was typing a whole like bunch of questions. But no, I clean everything and she goes like with a one sentence. Very short, not even writing the whole thing like before. No. Unbelievable. It's okay. It's the second day, so I'm going to forgive you. Okay? Thinking about quitting this profession. All right, so let's go back here. Creation of joint tenancy, as I was explaining. Creation of joint tenancy, there has to be 4 unities. There's a unity of time. So for a joint tenancy to exist, unity of time means that all parties must acquire the joint interests at the same time. Unity of title, all parties must acquire the property in the same deed of conveyance, right? Unity of interest, all parties must receive equal undivided interests. And unity of possession, all parties must receive the same rights of possession. So these are the 4 unities that must be present. That must be present with every JT. All right. All right, so termination by partition suit. What does that mean? So partition means separation, right? Partition means separation. So as I mentioned earlier, if I'm trying to sell my shares and I'm unable to, I can force the group to sell the building or force the group to separate the units. So if it's a duplex, we can turn it into 2 single families if the township allows, right? So this is my unit, that's your unit, right? So completely separate. So a partition suit, it has to be a lawsuit, right, is a legal avenue for an owner who wants to dispose of his or her interests against the wishes of the other co-owners. So again, it's me forcing you to get rid of the interest. So the suit petitions the courts to divide or partition the property physically, if possible, right, according to the owner's respective interests, rights and interests. If it's not reasonably feasible, so we cannot separate, like in a duplex, it's easy. It's side by side, so we should be able to say, I get the left side, you get the right side. Simple, right? But if it's not possible, right, then we're going to force the interest to be, the property to be sold and the interest to be liquidated and distributed proportionally. So if I have 50% shares, I'm going to force the sale, and whatever money it brings, I get my 50, you get your 50, and bye-bye. See you when I see you, right? So that's a partition suit or a lawsuit to divide our interest. Whether it's a physical partition, where we can physically separate the property, or it's a judicial partition, where the property is ordered sold, okay? And we get the money. Any questions there? That one was simple, right? Sell the property and that's it. All right, next. Tenancy by the entireties. When you see tenancy by the entireties is husband and wife, or nowadays recognized as spouse and spouse. Okay. So because most states recognize same-sex marriage, now it was changed in most states to spouse and spouse. All right. So the tenancy by the entireties, it's very similar. It's very similar to a joint tenancy in the fact that it carries the right of survivorship, right? If you guys remember from yesterday, we talked about homestead, right? We talked about legal life estates where we're married, therefore, when you die, I acquire yours, right? So by dower or courtesy or homestead, right? Or when I die, you acquire my shares. So you become 100% owner, right? So between the husband and wife, there's a right of survivorship. And we have, just like a joint tenancy, we have an equal, undivided interest. So we own collectively, right? The same thing as a joint tenancy, we own collectively. The distinguishing characteristics of tenancy by the entirety against a JT, the distinguishing characteristics is that it must be husband and wife. So they have to be, or spouse and spouse, they have to be married. That's one of the things that's different here. The other thing is that there's no right to partition. So I cannot force the separation of the property. The only thing I can do, the only type of lawsuit that exists in a marriage is divorce in terms of lawsuit. The other alternatives that we have is death, it's an alternative, right? Or a mutual agreement where we mutually agree to separate the assets. Okay, usually we find this in prenups, and now something that's becoming very common is postnups. After marriage, we both agree, yeah, we should have separated things, right? And yes, this is happening. It's becoming common. So you know, everything's turning into contracts. All right. So, going right here. Between husband and wife, or spouse and spouse, this is called tenancy by the entirety. Because we both own entirely or collectively the asset. We're both 100% owners. If you guys notice, it's just like the JT. There's no separation of our shares. I own 50, you own 50, right? But in the end, we're 100% owners. So if, and this, usually it's the most common thing to happen. If the wife is no longer there, husband becomes 100% owner, right? So instead of tenancy by the, I cannot even say this with a straight face. All right, so instead of becoming a tenancy by the entirety, now becomes a tenancy in severalty. So if there's only one owner, it's tenancy in severalty. Because, again, the wife is no longer there. And you're probably thinking, well, but doesn't it go to the kids? No. There's the right of survivorship. So husband is the first one to get it. Or if the husband dies, the wife is the first one to get it. And then it goes to the kids. All right? When it's property owned together or in a state where dower and courtesy still exists. All right? Now, let me ask you guys something. So this was the easy part. You guys already understood, I'm sure. Let me ask you something. What if we divorce? Okay? What if there's a divorce? Let's say, right? And fellas, I'm sorry. I have to be, what do you call it? I have to be reasonable with what I'm doing before I get sued. So at this moment, I'm going to kill the husband. I cannot always kill the wife, okay? I'm going to kill the husband for a second. I don't want to get sued for discrimination. We kill equally. That's what I'm trying to say. All right, so husband is dead. What happens to the shares? Let me know in the chat. Husband is dead. What happens to the shares? Look at everybody falling into the trap. Oh, did I warn you yesterday that I was going to trick you for the whole 4 weeks? Because the state exam, um, what? There's a there's a dead what? Oh, deep. Yeah, there was a dead one we buried somewhere underground, but um, yeah, we'll talk about the deed in a second. But what I want to point out, oh, Marlene, you're correcting it now, huh? What I want to point out is that the state exam and the school exam have very tricky questions. I don't understand why they do this. Rose, I see your answer there. Okay, but you fell into the trap as well. I don't understand why they do this for the state exam, because in real life, right, it's not going to trick you like that, and it's things you learn along the way, right? The exam should be treating you based on knowledge, not on hypothetical things, and tricking you, right? It doesn't make any sense to me, but it is the way it is, so I'm going to prepare you for it, all right? So here's the thing. You guys fell into the trap where I said, right, and you did not understood, and this is why you have to read slowly and listen slowly to what the question, to what is being asked. The first thing I said is, what if they are divorced? So if they're divorced, you think the husband dies and the shares go to the wife? The wife is no longer the wife. She's the ex-wife. So that right of survivorship ended when they divorced. So who gets the shares? Sam, thank you. The heirs do. The wife gets absolutely nothing of his 50%. You guys got it? So you need to be very patient when reading questions. A lot of you in the exam, especially, look, when I do this, do this for several years. When I do this proctor the school exams, right? I see what you guys do. You rush through questions, right? Some people finish the exam in less than an hour, and then you expect the result to be good. Most of the times it's not, right? You have to take your time. You have to read the question carefully, right? And very important, do not doubt yourselves. That's the first thing, right? You go with your gut feeling. But understand, there was a marriage, and I said, no longer married. That's the key right there. The moment we are not married, then we are ticks. If we still own property together somehow, we're blood-sucking, can't get rid of each other for the rest of our lives, even though the divorce is there, right? Happens. And you know how many people I know, that instead of separating their assets at the time of divorce, they say, no, we're divorced, we'll figure everything out later. Yeah. And then this happens. Well, I was supposed to get it because, you know, husband and wife, right? No, whatever you own together at the time of a divorce, now there's a separation. Now it's a tick. Okay? So we no longer have that beneficial interest, which is a survivorship. If you die, I get it. No, it goes to the heirs, individually owned. So is there a deed? Yeah, the deed will be there, Marta, so going back. The deed will be there, but there was a divorce. So it separates how we own the property. We no longer have tenancy by the entirety. We are ticks. So again, Marlene, I like how you went back on it, right? No, it goes to the kids because they are divorced. Yes. It's a matter of reading or listening in this case. Danny, unless there's a mutual agreement. Danny, are you married? No? All right, so that's why I understand this question. Yeah. Who would go to a divorce and in a mutual agreement say, hey, listen, we're divorced, but if I die, my assets are yours? Who? Tell me one person. Like, I love you so much, but we have to divorce. You still get my stuff just in case I die. My heirs will not get it. It'll go first to you. Right? So, it happened. I like the way you asked the question. That was so innocent. Right? Single people have no idea. Anyway. Rose says, not me. Nope, definitely not. All right. Sinead says, I did not listen. My bad. Okay, start listening because I'm going to do this all the time. I'm going to trick you guys so much. Right? I got to get you prepared. It's the same thing as going into a ring for a fight. Right? I got to hit you a couple of times for you guys to be ready to get hit during the exam, right? Marta, what about a last will and testament? Great. What about it? You're telling me again that in the will, I'm going to put that everything goes to my ex-wife. I can put in the will that everything goes to my ex-wife if that's what you're asking. Sure. But I'm thinking about my kids first, right? So I'll leave everything to the kids first. Can I leave the ex-wife as a guardian of the kids, for instance? Maybe. But the will is my decision. It's like a mutual agreement, like Danny was asking. It is my decision. The fact that we got divorced, what immediately happens is a separation of the assets. It doesn't separate the liability, but it separates the benefits, right? So I'm just putting it out there. It does not separate the liability. That might be a question about a divorce, and then the bank wants to foreclose. They're going to foreclose on who? Well, they're going to foreclose on both, and they can still collect the debt on both if we did not separate the liability with the bank as well. All right? So it separates the benefits, but it does not separate the liability. So remember that. A will could supersede everything. A mutual agreement, then it could supersede everything. Because again, it's a voluntary thing. Both of these are voluntary. Yes, I want my ex-wife to keep everything when I die. Right? That's what a will say. Again, I don't see one person that would do this unless you really, really, really love your ex-wife, but just cannot, or husband, but just cannot stand each other while together, right? I became best friends with my ex, but we don't work well together. So maybe. I still will not leave her anything, but we did become good friends, right? So yeah, put everything in the will. Sure. All right, community property. Some states have established a community property form of ownership. This type of ownership defines the property rights of legal spouses before, during, and after their marriage, as well as after the death of either spouse. Community property law distinguishes real and personal property into categories of separate and community property. Separate property belongs to one spouse. Community property belongs to both spouses equal. So, separate property consists of property owned by either spouse at the time of the marriage. So it's either owned by me or owned by you. Okay? Property acquired by either spouse through inheritance or gift during a marriage. Property acquired by separate property funds or income from separate property. So, just want to make this very clear. Some states, like state of New Jersey, for instance, if you had any of these happen to you, right, where you bought property with your own funds, okay, then maybe it does not belong to your spouse. Maybe. I'll explain how it belongs to your spouse in a second, how it could belong, or how they could get benefits from it in a second, right? If you inherited stuff, or somebody gifted property to you as an individual, not to the couple, then maybe it does not belong to the community or husband and wife, right? Okay? If it's an income from a separate property, if it's property acquired with separate funds, not related to the household or the marital income, then maybe it's owned separately. I see how some of you are taking close notes at this. I think this is the most I've seen people taking notes. How do I separate my assets from my spouse? Okay. All right. So community property is all property that was earned or acquired by either party during the marriage. So community property is we're now married, and anything we buy from now on belongs to both. So there are several agreements, and sometimes that's what happens in a prenup, is when we decide, hey, whatever I had before is mine, and any income that generates and any property that I acquire from before, it is mine. Whatever you had, it is yours. Whatever we buy while together becomes ours. Sometimes this is how prenups will stipulate how our marriage will be managed, right? So it could be separate. Now I was going to tell you how. Even though it's separate, the spouse could obtain benefits or rights or claims to the property, right? How could this happen? There's something called, we're going to talk about it in a different chapter, but there's something called equitable title or equitable interest. So if your spouse contributes towards any of those properties that you individually own, if they contribute with labor, right, or any funds that property, automatically they gain or start gaining beneficial interest or claims in the property. So if you want to keep things totally separate, make sure not even $1 or even one drop of sweat goes into that property by your spouse. Okay, that's one way to keep things 100% separate. There's other ways, right? But consult an attorney for that one. But as long as you keep things 100% separate, most states abolished dower and courtesy, where in a dower and courtesy did not matter whether it was owned by one individual or owned by another. If you were married, it belonged to both, right? So that's dower and courtesy. Most states do not have that anymore. So whatever's yours is yours, whatever's mine is mine. If we don't mix in any way, it'll keep on being separate, never community property. All right? You guys got it? Thumbs up? May 28, 1980, Danny. Yes, 1980. Okay. Juan, are you taking good notes on this? Juan? Are you taking good notes on this? I just want to make sure. Because I told Messiel I was going to tell you how to separate the assets from her. Okay, great. All right, so take good notes, right? All right, tenancy in partnership. It's a form of partnership held by business partners provided by Uniform Partnership Act. And the partnership tenancy grants equal rights to all partners, but the property must be used in connection with the partnership business, and individual rights are not assignable. I'll get to that better later on. All right, estates in trust. Estates in trust. So a trust is not a legal entity. A trust is an agreement by separate parties to join forces, right, to do something. And there's beneficiaries of the trust. So there's living trusts and there's land trusts. Okay? So there's a trustor, which is a person that owns or creates the trust and transfers legal title to a fiduciary or a trustee. A trustee is a third party. So let's say the trustor is me and Marlene. So Marlene and I, we are the trustors. We created this trust and we found a trustee. So Nidia, you're going to be the trustee. We appointed you, almost like a property manager. We appointed you to handle all the interests of the trust. And then there's a beneficiary. Okay? Who's the beneficiary? Well, it could be us. Right? Never the trustee, but it could be whoever created the trust. It could be the beneficiaries. All we're saying is a trust similar to an LLC creates a shield or a separation of who owns the property and who benefits from the property. Okay? So the trustor gives the title the deed and stipulates an agreement to the trustee. So again, Marlene and I created the trust. So we entrusted our title, deed, and by agreement gave powers to the trustee who owes us specific duties. So they're managing our assets, right? And they're the front of the property. So when people search public records, they don't see Marlene and I. They'll see the trustee. But is the trustee the owner? No, they're just a manager, right, of the property. So the ownership, the benefits, right, and the duties go to the beneficiary, which could also be Marlene and I, regardless. All right, so think about this in a life insurance. If this were a life insurance, right, I'm sure you guys know life insurance, or if this was any type of insurance, right? Think about this one, the trustee as the insurance company, right? What we're saying is, insurance company, if anything happens to me, any liability, any claim, right? If anything happens to me, the monies that are being collected are going to be paid out to X, Y, and Z. To be me in a car accident, if anything happens, right? They can pay me to fix the car. Or in the life insurance, usually we attribute the benefits to one of our heirs, as an example, or all of our heirs. So the insurance company acts as a trustee. Are you guys understand this? So we create it, we appoint somebody to handle everything, and we reap the benefits of it. It just creates a separation between title and who really owns it. So if somebody sues, they're going to sue the trust, right, through the trustee. So the trustee is not liable for it, but they're going to sue the trust. They can never sue the beneficiaries, Marlene and I. Okay? So it's a separation. That's all it is. Sam is asking, can you zoom that? We are on Zoom already. Where do you want me to zoom? Okay. So zoom, zoom, slow zooming. Now I'm panning. I already zoomed. Now I'm panning. Good? All right. So that was a trust, but there's living trusts and there's land trusts. Okay? A living trust allows the trustor, so the person that creates the trust, right? Trustor during his or her lifetime to convey title to a trustee for the benefit of a third party. The trustor charges the trustee with all the necessary responsibilities for managing the property, protecting its value, and securing whatever income it may produce. The trustee may also be ordered to sell the property at a given point. The beneficiary receives all the income and sales proceeds net of the trust fees. Okay? Testamentary trust. So when we create a will and testament, right? Testamentary trust is structurally and mechanically the same as a living trust, except that it only takes effect when the trustor dies. All right? So a living trust is while I'm alive. This is what happens with the property, with the assets. Somebody else handles it, and I receive the benefits of it minus the fees of the trustee. So again, like a property manager, very similar. Okay? Testamentary trust means that this only takes effect when I die, right? Then the trustee takes over. A land trust allows a trustor to convey fee estate to the trustee and to name himself or herself as the beneficiary. Again, as I was saying before, we create, right, the trust, and we become the beneficiaries of the trust. The land trust applies only to real property, not to personal property. So the agreement or deed in trust grants the beneficiary the rights to possess and use the property and to exercise control over the actions of the trustee. The conventional trust structure, as it says right here, the trustee holds the legal title and has conventional fiduciary duties. The trustor must be a living person, and the beneficiary may be a corporation. So if you want to have even more protection, you can put the beneficiary as your LLC, for instance. Right? The distinguishing characteristics of land trusts are that the beneficiary controls the property. This includes occupancy and control of rents and sales proceeds. Beneficiary controls the trustee. So we give certain powers to the trustee. They cannot do whatever they want. They need our approval. Okay? And again, as I was saying, the beneficiary identity is not on record. You want to hide from the public? Simple. Create a trust. Way better than an LLC, because an LLC, right? Let me just clarify this. I love LLCs, okay? But if you don't want to be on record, an LLC, I can go to the Secretary of State and download your documents and see who the owner of the LLC is. A trust is not recorded with our names. Okay? So, beneficiary identity not on record. So, public records do not identify the beneficiary. The beneficiary owns and enjoys the property in secrecy. So, a lot of states have this, like Wyoming is great for trust, to create a trust. They have like ridiculous amount of mesh structures. This is for asset protection. I mean, most people will never even do this, but if you own property free and clear, this is one of the things you should do, right? So there's mesh protection, which is a blend of trusts and LLCs, just to completely hide what you own or not, so nobody can come collect from these properties that you already own, okay? And there's limited terms. So the term of trust is limited and must be renewed, or else the trustee is obligated to sell the property and distribute the proceeds. What is beneficial interest? The beneficial interest in land trust is a personal property, not real property. So the beneficiary does not own the property. Who owns the property? The trust. Like an LLC, the LLC owns the property. Like a corporation, the corporation owns the property. The beneficiaries own interest in the trust or stock in an LLC or shares in a corporation, right? So they do not own the property, they own personal property. Who owns the real property? The trust, the LLC, or the corporation. And that's why there's a separation between what the public sees and what you see. So they do not see you, right? This distinction offers certain advantages in transferring, encumbering, and probating the beneficiary's interest. In transferring, okay, one of the benefits of transferring through a trust or even an LLC, that you can transfer the trust itself or assign the benefits of the trust, just like in an LLC, I can assign the stock or the shares. I don't need to sell the property. So instead of having a deed, we just transfer the interest in the trust or in the LLC. So these are very similar. That's why even though it doesn't mention the LLC here, I'm using both the same way. Encumbering. The beneficiary may pledge the property as security for debt by collateral assignment rather than by recorded mortgage. So when there's a search, public records, there's no lien against the property, right? Probating. What is probating? Well, when somebody dies, it has to go through probate court to determine which creditors have rights to the property. And if there's no creditors, who gets what? Who are the heirs, the rightful heirs of the property? So the cool thing about interests in trusts or benefits in trusts, that the trust does not die. You do. So instead of going to probate, it continues to the contingent beneficiaries. So if you're not there, could it pass down to your other beneficiaries, like your heirs? So the trust does not die. There's no sale, transfer. Does that make sense? All right. So there's a lot of stuff that could be used for asset protection, especially from probate, where the creditors can come and say, well, You know, this person is no longer alive, so we need to get paid. Heirs, you get the balance, or you need to pay us everything now, right? So great benefits to this. Any questions before I proceed? By the way, in an investment course, you will learn about trusts, land trusts, in a lot more detail, right? So this is just a slight touch to what the trust, the power of a trust. Questions? Got a lot of people on YouTube today. Guys, if you have questions, ask questions on the YouTube live chat, please. I will help you, and your questions will help my live students right now. And I don't know how, but my 6-year-old daughter, with horrible at reading, just got an A+ reading. Horrible. I'm gonna be honest. She's got an A+. Guys, we can't always protect our kids. We have to be honest to them. They're horrible. You gotta say it. That's it. She's great at other things. She's very artistic. Draws like stuff that I'm like, wow. But reading, horrible. All right. So, any questions? All right, move forward. All right, no questions on YouTube, no questions on Zoom, so you're going to move forward. All right, so now we're going to talk about ownership by business entities. So I already mentioned briefly LLCs, for instance. There's corporations and there's partnerships. The advantage of these two, okay, not this one. The advantages of these two, corporation and LLCs, is that they have a shield, right? And what shield am I talking about? It's a liability. Liability shield, okay? Because both corporations and LLCs will own the property, okay? Just like a trust owns the property. Therefore, if anybody sues the LLC or the corporation, they're not suing you as an individual. They're suing the corporation's assets, okay? So you as an individual can get sued directly if you have a partnership and there's not enough money in the partnership to pay for the damage. So if somebody slips and falls and there's not enough insurance, as an example, to cover the damage of that slip and fall, in a partnership, it's passed through. That means you got $100,000 in your partnership, great, but the costs are $1 million. Well, now it can force, so it goes beyond the partnership, it can force each individual partner to sell their assets in order to meet their personal assets, in order to meet the lawsuit. In an LLC or a corporation, that does not happen. If the corporation has $100,000, then it's limited to the $100,000 the corporation has or the LLC. All right? So it's a shield, it's a separation. Okay? Page 47, yep. Marlene, yours is the first edition? Or second edition? No, I know, but is it first edition or second edition? Can you read about it? First edition? Okay. Hold on. We just got these a couple of weeks ago. So if you have the physical book, it says first edition. Just let me know in every chapter what you don't have. Sam, sucks for you. All right, so I just shared with you guys, this is today's chapter. Okay. We're on page 47 of that, okay? Good? All right. So, back to what I was saying. So both corporations and limited liability create that separation. So I go over the review questions with you. So what I usually like you guys to do, and because I'm not like most schools where they just rush through things, right? I like to take my time. What I usually like you guys to do is to do the review questions at home, right? So that's at home. You're at home anyway. But after class, do the review questions, and that's something that I say every time before I start the each chapter. That if you have any questions, drop them in the chat so I can address. So after you do the review questions, Sinead, if there's anything there that you see, well, Bruno, why is it A instead of C, right? Post that question, right? Just type it or do a screenshot and share in the Zoom chat, and I'll explain to everybody, right? So that's the way I like to do it. I don't like to. I used to do years ago. I used to do the review questions at the end of each chapter, and if I do it in class, then it's the same thing as me teaching, and you guys will not get it. So you'll get used to that. I prefer that you take that as homework, and then give me your questions of the homework, right? Regarding the homework, and I'll address it in class, right? Cool. Great. All right. So back to this. Corporation. So a corporation is a legal entity owned by stockholders. An elected board of directors oversees the business, and officers and managers conduct day-by-day activities. Officers and directors may be held fully liable for the corporation's actions, while shareholders are liable only to the extent of their value of their shares. Corporations, like individuals, may own real estate in severalty or as tenants in common if it's two or more corporations, right? Now, in a partnership, two or more persons agree to work together and share profits. Look what it says. A general partnership is not a distinct legal entity like a corporation. So like I was saying before, there's no shield when it comes to a partnership. It's not a separate entity, okay? Limited partnership has, all partners bear full liability for debts and obligations, and a limited partnership has two or more partners, one or more being general partners and the others being limited. The general partners run the business and are liable for debts and obligations, while the limited partners are liable only to the extent of their investment in the partnership. Okay? One of the things to remember about limited partners, these are the silent partners. So there's general partners and there's limited partners, right? The general partners are the ones that have the voice or the saying in the daily activities of the business. And that's why they have full liability for debts and obligations. Where limited partners, because they're not active participants in the business, they're passive, they're limited to the amount of money that they put in. So if I put in $10,000, right, but I don't do anything with the business, and the business gets sued for $1 million, I only lose the $10,000. You, however, if you are the general partner, you are liable for the full $1 million. Does that make sense? So general partners, fully liable for debts and obligations. Limited partners, they're only limited, or silent partners, they're only limited to their investment, so the amount of money that they put in. Right? And that is the same thing as an LLC. LLC is my favorite. Okay? An LLC is easy to set up. That's why it's one of my favorites, right? But it combines the features of a corporation and the limited partnership. So it's a hybrid between a corporation and a partnership. See, the LLC offers its members the limited liability like a corporation, so the shield, the protection, the separation, but the income is passed directly to the members and is taxed to them as an individual income. So in a corporation, you get double tax. You get taxed as a corporation and you get taxed as an individual. In an LLC, just like a partnership, we file a partnership split, let's say, right? That says company made X amount of dollars in profit. We split amongst all the partners. This is how much you're responsible or liable in your taxes. So here, $25,000 is what you made this year towards this property, this LLC. So declare this on your taxes. It's called a Schedule K, right? So on your taxes. So it's passed through. You don't have to be double taxed. Great advantage. The other thing is the management structure is flexible. See, a corporation, you have to have board of directors, you have to have minutes, you have to have regular meetings, and again, the minutes you have to write down everything you have in that meeting. So if it's a sole owner, like if it's a single owner corporation, you still have to have meetings with yourself and write down every time you talk to yourself. Okay? So it's horrible, corporations. That's why it does not make sense if you're one person to have a corporation. Quite honestly, if it's 10 people, still does not make sense to have a corporation for me, right? Now, if it becomes 100 people and it starts needing more hefty type of management, right? More complex management. Maybe a corporation is a little bit better than an LLC, right? But if you have something simple that you're handling, like one real estate property, 2 real estate properties, maybe 10, 20, maybe, it's simple to manage. It's not a complex type of structure. LLCs all day. Does that make sense? All right. Now, like a corporation or a partnership, the LLC may own real estate. That's why I have an LLC for every single property, right? So one of the things you guys can do, and this will be real quick because we have to move forward, but one of the things you guys can do is have what's called an S Corp. And you can call this the umbrella, or also known as a holdings company. Okay, and then under the S Corp, you can have LLC 1, LLC 2, LLC 3. So if you own 3 properties, they're all individual LLCs under the S Corp. And just so you guys know, the advantage of this is so you don't pay self-employment tax, or you reduce your liability in taxes, because these LLCs are owned by the S Corp, and you can take a salary out of this. This one can pay a salary, this one cannot. So now you qualify for unemployment, and you have the benefits of all your LLCs. Look at that, right? Anyway, consult a CPA. If you don't have one, I can recommend one. Are you guys good so far? Give me a thumbs up if you're good so far. Okay. Some of you, I imagine how you guys were in school. Like, did you always like walk around in the middle of classes? Some of you cannot stay still. Unbelievable. You'll do great in the state exam. I'm telling you, teaching adults is worse than teaching kids. Kids, we already predict. Stay still, sit down. We already know that, but adults, whew. David, you're making me dizzy. Stop. Sit down. Just don't complain later, okay? Is that a deal, guys? Don't complain later. Anyway. All right, condominiums. Who knows what a condominium is? Let me know in the chat real quick. What is a condominium? I like this answer. What is a condominium? It's a condo. Sure. It is. We know more commonly as condos. We don't say condominium. Condos. Correct. Alexis says it's a hybrid form of ownership. Did you just Google this? A hybrid form of ownership of multi-unit residential or commercial properties. Right? I can even see this in a Morgan Freeman type of voiceover, right? I love this. Hard to sell. So true. Easy to buy, hard to sell. And I love honesty. I just hate when people yell at me. Make sure you take the caps off. I hate when people yell at me. Okay? All right. So what is a condo or condominium? So we most commonly know them as condos. Yes. It's a hybrid form of ownership of multi-unit residential or commercial properties. I would like to see Alexis in the middle of the state exam and be like, hey, the book was right next to me. All right. It combines the ownership of fee simple interest in the airspace within a unit with ownership of an undivided share as a tenant in common of the entire property's common elements, such as lobbies, swimming pools, and hallways. Ooh. Rose, there's only one thing wrong with your statement. So hold on a second, I have to address this. So Rose said apartments owned by tenants who shared amenities equally. So you're thinking about co-ops. The moment you said tenants, co-ops, which we're going to talk about later. See, in condos, right, you have fee simple ownership. You're not a tenant. So you're very close to the definition. Just change where it says tenants, right, to individual owners who share, okay, common elements. All right. So in the simplest form, you have a building or a community where we own one unit and we share common elements. Okay. So that's the simplest definition of condominium. If it's in a building, in a single building, then you have airspace. That's what you own, right? But even if it's a single family or whatever, we own airspace because we cannot change the exterior. So we only own what's inside. It's like owning a shoebox, right? In fact, you own only, so you guys know, from the paint inward. From the paint outward, it's no longer yours. It belongs to the community. So it becomes common elements. Now, condominium unit is one airspace unit together with the associated interest in the common elements. Rose, you're very welcome, and thank you for participating. Now, the unique aspect of the condo is that it is fee simple interest. So again, fee simple means you have ownership, okay? Interest in the airspace, combined with outer walls, floors, and ceilings of the building units. The airspace may include internal walls, which are not essential to the structural support of the building. Now, common elements are all portions of the property that are necessary for the existence, operation, and maintenance of condo units. Common elements include land, structural components of the building, such as exterior windows, roof, and foundation, physical, operating systems supporting all units, such as plumbing, power, communication installations, and central AC. Recreational facilities, building and ground areas used non-exclusively, such as stairways, elevators, hallways, and laundry rooms. So we own it together. We share it. Okay. Orphelia, I see what you wrote. Multi-unit or commercial. Yep, it could be. There's a commercial condos as well. Yes. There's commercial co-ops as well. There's residential co-ops as well. Okay. So perfect. So here's a condo. This is a building, and this is your unit. You own the airspace inside. Okay. You do not own the exterior walls. Okay, or the structural walls. You own the airspace inside. We share common elements like the swimming pool, the garage, the parking, or even the driveway. So we share common elements. But the only thing we own, really, let me zoom in again. The only thing we own is the airspace. So when Rose wrote tenants, it is very similar to being a tenant. As a tenant, you can occupy and you can make changes to the interior, right? But never to the exterior. And when I say changes to the interior, we're talking about moving personal property, right? So you can put whatever furniture you want, it's yours. You want to change the light bulbs, right? But you cannot rearrange the walls either, the structural walls, okay? And the exterior is shared with all the other tenants. So I will piggyback on that, but I just want to make sure you guys understand when it says condominium, right? Very, very similar to the tenant rights, which is just the airspace, but you actually own the unit. You have fee simple ownership, right? A little different than co-ops, which is only tenancy, so renters. All right. So what are the interests and rights that you have in the condominium? I'm going to share 2 PDFs with you guys in a second, okay? So the condominium unit can be owned jointly, in severalty, in trust, or in any other manner allowed by state law. Unit owners hold an exclusive interest in their individual apartments and co-own common elements in the other units as tenants in common. So again, we are ticks only in the common elements. In our unit, we own in severalty. It's ours and ours alone. Okay? Possession, use, and exclusion. Unit owners exclusively possess their apartment space, but must share common areas with other owners, as I just said. Okay? Transfer and encumbrance. Condominium units can be individually, as you see here, individually sold, mortgaged, or otherwise encumbered without interference from other owners. So I can sell my own unit, and if I default, if I stop paying in my unit, does it affect your neighbor? No, because it's individually owned. If I lose my unit, right, the only thing that might affect their units is the value, but it does not affect their ownership. Okay, so that's a little bit different from co-ops, because in a co-op, if enough people stop paying their dues, or if they default, the whole building can get sold. So, as a distinct entity, the condominium unit may also be foreclosed and liquidated, and an owner may not sell interest in the apartments separately from the interest in the common elements. All right? Condominium units are also individually assessed and taxed. If you guys notice, everything that I highlighted here in green talks about being individual, right? Distinct entity, individually assessed and taxed, right? Everything's individual because condo, that's what you have, okay? How do you create a condominium? So how do you create a condominium? I just shared with you guys two PDFs, okay? One is for condo versus co-op. The other one is for that joint tenancy, tenants in commons, and so on. So, condominium properties are created by executing and recording condominium declaration and a master deed. So what is a master deed? Well, the master deed covers the whole land, right? It says who the owner of the land is. Because remember, we are co-owners of the land, right? So the homeowners association, or in this case, the developer creates the bylaws and owns the master deed, which then will define each individual unit, and they have their individual deeds. Okay, but the master deed covers the whole condominium. Okay, declaration must be legally correct in form and substance according to local laws. So every state has their own rules regarding condominium laws, right? And the party creating the declaration is referred to as a developer. The condominium, by the way, there might be a question regarding this. The developer is the one that creates the condo, okay? The condominium may include ownership of the land or exclude if the land is leased. What are the declarations that we find? Just like every other deed, it must state the legal description and or name of the property. Right? Legal descriptions, you guys are going to learn later what they are. But legal description and or name of the property. A survey of the land that shows what we own, right, as common elements, and all units. Plat maps of the land and building and floor plans with identifiers for all condominium units. Provisions for common area easements. We'll talk about easements as well, coming up soon. An identification of each unit's share of ownership in the overall property. Organization plans for creation of the condominium association, including its bylaws. Bylaws are just the sets of agreements of what we can do or not do with the properties, for instance. Voting rights, membership status, liability for expenses of individual owners, and then covenants and restrictions. All right, these are called CC&Rs, covenants and restrictions, regarding use and transfer of units. So, the organization of a condominium, look, I don't have it highlighted, so I'm going to go very fast over it. But organization, there must be a declaration of homeowners association and who's going to manage and how they're going to manage, how can they enforce the bylaws and so on. And they assign a board of directors, almost like a corporation. Some of them call it board of trustees. Doesn't really matter, but it's how it's set up and how often the meetings should happen. They have to establish also the management of the common elements, right? There has to be rules, regulations regarding the timely management of common elements. The responsibilities for each individual owner to maintain their internal system, to maintain the property condition, and to ensure the contents of the unit, because everything outside of the unit must be insured by the HOA. Okay? Common area assessments. The unit owners bear the costs of all other expenses such as maintenance, insurance, management fees, legal supplies, legal fees, and repairs, obviously of their individual units. Right? And an annual operating budget totals these expenses and passes through them as assessments, or as we call also HOA fees. Right? So these assessments is how much you have to pay on a monthly basis to the HOA for, again, maintenance, insurance, management fees, supplies, legal fees, and repairs of the common elements. Okay? If you guys fail to pay, a lot of people don't know about this. If you fail to pay the HOA fees, right? Some of you, I'm going to pay my mortgage instead of paying, well, you should not default on either one of them, but life happens, right? I'm going to pay my mortgage, but I'm not going to pay the HOA fees. Well, if you don't pay the HOA fees, they can actually initiate a court action to foreclose on your property. So I'm not gonna pay it I'm gonna pay it $2,000, but I'm not gonna pay the $200. Either one of these could lead to foreclosure. Putting it out there. Either one of these could lead to foreclosure. You could lose your unit for not paying those $200 a month. Okay? You guys good so far? Thumbs up? Right? Cool. I'm going as slow as I can in certain things, okay? Now, co-ops. What are co-ops? So, a co-op is a corporation, right, that owns a building and sells the stock. Okay? So a co-op is a corporation that owns a building and sells the stock. While selling the stock, they give a right to the stockholder, to whoever purchases stock, they give the right to the stockholder to occupy one unit in the building. All right? So pretty much you are a tenant shareholder. You're a tenant because you're allowed to occupy a unit, right? And you pay fees for that every month. But you are a shareholder. That means you are kind of like a partner in the corporation that owns the building, right? So cooperatives pretty much is run by tenant shareholders. Here you go. In a co-op, you own shares. So you own shares and you do not own real estate at all. Okay? Who owns the real estate? Let me know in the chat. Who owns the real estate? Anybody? Who owns the real estate in the co-op? If you own shares, who owns the real estate? The corporation, correct. So the corporation owns the building. You own shares, and along with those shares or stock, you get a proprietary lease to occupy one of the apartments. Okay? So again, you're called a tenant shareholder. So let's look at this. This is very similar to the condo, remember? Very similar, right? The difference is right here. In the condo, you owned the airspace. Now here, you lease the space. So you are a tenant. What you own, instead of the airspace or the unit, you own a stock or a certificate to 1/9 of it all, because there's 9 units in this case. You still have common elements. Rose, so now the owner of the building in this case is a corporation to which you are a stockholder. Okay, so there's 9 units. You own 1/9 certificate. Okay, so 9 certificates are being sold in this building, and then we all share again the pool, the garage, the parking, the driveway, and all other common elements. Okay. So the cooperative association's interest, the corporate entity of the cooperative association is the only part of the cooperative with real property interest. What does this mean? The corporation owns the real estate. You own stock and the lease. So what you have is personal property. You own a piece of paper that says you have the right to occupy one of the units. That's it. Okay? But the corporation is the one that owns the building. You guys good so far? You with me on this? I want to make sure. All right. Don't just give me a thumbs up. If you have questions, make sure you ask, okay? So, as I was saying here, the association's interest is an undivided interest in the entire property, and there is no ownership interest in individual units. What we have is a shareholder's interest, right? So we own stock and the lease. Unlike a condo ownership, the co-op owner owns neither a unit nor undivided interest in the common elements. So pretty much everything is shared. What you do get is a proprietary lease. So the co-op lease, and of course if it says lease, you are a renter, you are a tenant. A co-op lease is called a proprietary lease because a tenant is an owner or proprietor of the corporation that owns the property. So do you own, in a corporation, do you own real estate? In a co-op, do you own real estate? No. You own stock to the company that owns the real estate. All right? So the lease has no stated or fixed rent. Instead, the proprietor tenant is responsible for the unit's prorated share of the corporation's expenses in supporting the cooperative. So unit owners, they pay monthly assessments. Expense liability. The failure of individual shareholders to pay monthly expense assessments can destroy the investment of all other co-op owners if the co-op cannot pay the bills by other means. So pretty much what we're saying is there's 9 units over there. If 5 of those 9 units stop paying, do you think we're going to have enough money to pay for all the assessments like a mortgage, taxes, insurance for the whole building? Are we going to have enough money? Probably not. So that's one of the problems. Since the corporation owns the undivided interest in the property, debts and financial obligations apply to the property as a whole, not to individual units. So, should the corporation fail to meet its obligations, creditors and mortgagees may foreclose on the entire property. See, in a condo, if you stop paying your taxes, mortgage, insurance, right, you lose your unit. And it does not affect your neighbors. In a co-op, you own it together because you own stock in the corporation that owns the building. So if people stop paying, the whole thing can get lost in a foreclosure. All right? You guys good? Keep on asking because these are difficult things here. All right. The next thing we have is very brief, is time scams. It could be a lease or it could be freehold, so you can rent it or own it. Now, timeshare ownership is a fee or leasehold interest in a property whose owners or tenants agree to use the property on a periodic, non-overlapping basis. So this type of ownership commonly concerns vacation and resort properties, and timeshare arrangements provide for equal sharing of the property's expenses among the owners. So what happens is, either as a lease or as a freehold, as a lease, you have the right to rent a particular unit for 1 week of the year, for instance, right? As a freehold, you own an interval in that particular timeshare or in that particular property over the year. So it's very similar. It's just one you have only the renting rights, the other one you actually own and get benefits from it, right? So either way, all of them have a prospectus of the corporation or of the timeshare, which should be shared with you and explain the rights benefits they might have. So interval owners must usually waive the rights to partition. So one of the things that they don't tell you, right, is this: the right to partition, meaning you cannot sue the other owners to sell the timeshare. So you're going to have difficulty, I can guarantee you this. It's like condos. They're easy to buy, very difficult to sell. You're going to have difficulty selling your timeshare if you don't use it. But you cannot, because you waived it, you cannot force the sale of the entire property in order to recover your money. That's one of the things. All right? Another thing that they don't tell you is this: you're going to buy the timeshare that allows you to go there once a year or twice a year or to a bunch of different resorts or whatever, but they don't tell you that you're also obligated to pay 1/12 of the expenses every year. So maintenance. You only occupy 1 week. but you pay year-round maintenance, that timeshare, right? A few things that they don't tell you up front. They give it to you in the prospectus, which usually only after you sign is when they give you that prospectus, okay? All right, guys, those are the important things you need to know about this. Do you have any questions right now before we end this chapter? Yes? No? All right, cool. Don't forget, in the Zoom chat, I shared with you guys 2 PDFs. Make sure you download them before the class is over. Download those. It's comparisons between different types of ownership. So the severalty, the TICs, JTs, entireties, right? And the other one is condos versus co-ops. So it shows the clear difference between one and the other. All right? So with that being said, guys, it's 12:27, almost 28. So we're going to take a quick break. We'll be back in 12 minutes. So 12:40, we are back, okay? So you got 12 minutes to go run, exercise, get your blood flowing again, and get back fully energized for Chapter 5. All right, guys? See you in a bit.